5 seconds to go. Start. But as we have pointed out above, RBI is not just any other statutory authority. It is not like a stream which cannot be greater than the source. The RBI Act 1934 is a pre-constitutional legislation which survived the Constitution by virtue of Article 372(1) of the Constitution. The difference between other statutory creatures and RBI is that what the statutory creatures can do could as well be done by the executive. The power conferred upon the delegate in other statutes can be tinkered with, amended, or even withdrawn, but the power conferred upon RBI under Section 3(1) of the RBI Act 1934 to take over the management of the currency from the central government cannot be taken away. The sole right to issue bank notes in India conferred by Section 22(1) cannot also be taken away and conferred upon any other bank or authority. RBI, by virtue of its authority, is a member of the Bank of International Settlements, which position cannot be taken over by the central government and conferred upon any other authority. Therefore, to say that it is just like any other statutory authority whose decisions cannot invite due deference is to do violence to the scheme of the Act. In fact, all countries have central banks authorities which technically have independence from the government of the country. To ensure such independence, a fixed tenure is granted to the Board of Governors so that they are not bogged down by political expediencies. Therefore, we do not accept the argument that a policy decision taken by RBI does not warrant any deference. In further analyzing the wide-ranging powers entrusted with the RBI, the court noted that its regulatory powers would be tested against the cornerstone of proportionality. It is no doubt true that RBI has very wide powers not only in view of the statutory scheme of the three enactments indicated earlier, but also in view of the special place and role that it has in the economy of the country. These powers can be exercised both in the form of preventive as well as curative measures, but the availability of power is different from the manner and extent to which it can be exercised. While we have recognized elsewhere in this order the power of RBI to take a preemptive action, we are testing in this part of the order the proportionality of such measure for the determination of which RBI needs to show at least some semblance of any damage suffered by its regulated entities, but there is none. When the consistent stand of RBI is that They have not banned VCs, and when the government of India is unable to take a call despite several committees coming up with several proposals, including two draft bills, both of which advocated exactly opposite positions, it is not possible for us to hold that the impugned measure is proportionate. Stop.